Judgment in the matter of the Queen on the application of Newby Foods Limited versus the Food Standards Agency.
The decision of the court in this case will be explained by Lord Sales.
This case is about the application of European Union food hygiene rules to certain chicken and pork products manufactured by the appellant, Newby. The question on appeal is whether these products should be classified as mechanically separated meat, or MSM, within the definition given in Annex 1 to EU Regulation number 853 of 2004. Newby argues that they should not be classified as MSM. The Food Standards Agency contends they should be so classified. The answer depends on the proper interpretation of the judgment of the Court of Justice of the European Union, the CJEU, given at an earlier stage in these proceedings, which addressed that issue. It is now common for the initial butchering of animal carcasses in the food industry across the EU to be carried out by machines. These often leave a significant amount of meat on the bone. This case concerns the removal of meat left on the bones after the initial phase of mechanical butchering, in the case of pork carcasses, and after the initial phase of mechanical removal of chicken breasts, in the case of poultry. Classification of meat products as MSM, under the definition in the regulation, is significant because there are strict limits regarding the use and labelling of MSM as compared with other fresh meat products. Consequently, the commercial value of MSM is much lower than that of other fresh meat products. Newby has developed a machine to remove residual meat from carcass bones. Originally, this was used in relation to removal of meat from beef, lamb, pork and chicken carcasses. The Newby process has two stages. First, meat-bearing bones are forced into contact with each other to remove meat by shearing forces, and second, meat so removed is then passed through a machine which produces a product similar in appearance to minced meat. Newby's meat product was previously known in the UK as desinued meat. It was widely regarded as distinct from MSM, including originally by the FSA. However, desinued meat is not a category recognised in EU law, and the European Commission took the view that Newby's products fell to be classified as MSM under the EU regime. On the 4th of April 2012, after taking account of the Commission's views, the FSA issued a moratorium regarding the position on classification of desinued meat, with the result that first, it could no longer be produced from residual meat on beef and lamb bones, and second, it could only be produced from residual meat on chicken and pork bones if classified and labelled as MSM before sale to the public. Newby brought judicial review proceedings challenging the moratorium. In July 2013, the High Court made a preliminary reference to the CJEU on the definition of MSM in the regulation. The CJEU gave a judgment on that reference on the 16th of October 2014. After that, Newby abandoned its challenge to the moratorium as regards lamb and beef carcasses, but not as regards pork and chicken. When the case returned to the High Court, the judge reviewed the CJEU judgment and concluded that, according to the guidance in that judgment, the pork and chicken meat products resulting from stage 1 of Newby's process are not MSM. The Court of Appeal allowed the FSA's appeal against that decision and dismissed the challenge to the moratorium. Newby now appeals to the Supreme Court on the proper interpretation of the definition for MSM in the regulation. The proper interpretation of the definition in the regulation depends upon the ruling in the CJEU's judgment. The CJEU gave technical guidance regarding the interpretation of the definition. This court finds unanimously that the Court of Appeal proceeded on the basis of a proper understanding of the CJEU's ruling. There are a number of strong indications in that ruling which support the Court of Appeal's reading of it. As appears from the ruling, the CJEU interpreted the definition of MSM so as to provide a clear demarcation between MSM and other meat products. That clear demarcation would be obscured on the approach contended for by Newby. According to the CJEU's ruling, the definition of MSM covers meat products removed by mechanical means at a second stage after the initial phase of mechanical removal of meat from a carcass when it is first butchered. At various points in its ruling, the CJEU indicated unambiguously that it considered that the meat produced by Newby's process fell to be classified as MSM for the purposes of the regulation. The court is unpersuaded by the submissions for Newby that the CJEU misunderstood the evidence regarding Newby's process, such that the court should disregard these clear indications by the CJEU. On the contrary, the court finds that the CJEU was well informed about Newby's process and that it is appropriate to follow the indications the CJEU gave about the application of the definition of MSM to the meat products produced by that process. In the light of the CJEU's ruling, the position is acte clair, that means completely clear, and no further reference to the CJEU is needed.
The court will now adjourn.